everyone, my name is Thunyaporn Pattarapipatkul. My video will present about the shareholder liability for piercing of the corporate wealth. The reason why I choose this topic are because the business in Thailand become popular among investors, so there is a chance that the shareholder may establish company in bad faith against the creditor and they can escape from the liability because under Thai Civil and Commercial Code, shareholder in private limited company cannot be personally liable for the company debt. So we have to study shareholder liability in Thailand and see whether we should adopt the piercing of the corporate wealth or not by comparing Thai legal system with the German and US legal system. First, we should know what is the piercings of the corporate wealth. Generally, company has separate legal entity from its shareholder according to the separated legal entity principle. Moreover, liability of the shareholder will be limited due to limited liability concept under section 1096 of the Thai Civil and Commercial Code. So, piercing of the corporate wealth means that we disregard the corporate entity and look for the real person who take control of the company. When shareholders use the corporate personality of the company as a means to commit fraud, the court will lift the corporate wealth and see who is behind the wealth in order that the creditor can directly sue shareholder. So the consequence is that shareholder will be jointly liable with the company or personally liable for the company debt. In Thai legal system, under Thai Civil and Commercial Code, there is no provision of holding the shareholder personally liable for the company debt, but the court have brought the related provision to decide the liability of shareholder for piercing of the corporate wealth. For example, agency law under Thai Civil and Commercial Code, Section 44 of the Consumer Case Procedure Act or the CCPA, and Section 5 of the Thai Civil and Commercial Code, which is the good faith principle. However, there is still the problem to apply. For example, under Section 44 of the CCPA, a shareholder will be liable as a joint defendant only if there is the damage to the consumer. Therefore, piercing of the corporate wealth in Section 44 of the CCPA can only apply to the case that the plaintiff is the consumer only. Next, the German legal system. It is the civil law system which the limited company will be governed under German limited liability company law. As Germany does not have written law concerning shareholder liability for piercing the corporate wealth like Thailand, the liability of shareholder will rely on German case law and literature that provide the court's previous decision what situation that shareholder will be personally held liable for the obligations. However, when there is an event that shareholder may be personally held liable, most of the cases the court will apply tort principle rather than directly apply piercing of the corporate wealth to make shareholder liable for the creditor. Next, according to U.S. legal system, it is the common law system where the court decides the case by looking at the precedent case, so-called the case law. U.S. sets many effective standards to consider the piercing of the corporate wealth. For example, the case of the Laya and Erin Homes that the courts apply the piercing of the corporate wealth to consider the shareholder liability into 19 categories, as you see from the slide. For the final part, which is the recommendation and solutions, I recommend that Thailand should apply piercing of the corporate wealth concept in order to hold shareholder personally liable for the conduct that shareholder established the company in bad faith. Because without piercing of the corporate wealth, shareholders are not personally or jointly liable with the company debt according to the limited liability concept. So shareholder can shift all the blame to the juristic person and set another new company for committing fraud again and again. So there are two recommendations of issue of the shareholder liability. First, we should revise Section 1096 of Thai Civil and Commercial Code by setting that what cases that shareholder should be personally liable other than the value of the share price. For example, in the case that shareholder of private company have established the company for conducting illegal business purpose, fraud, or shifting the company asset for the benefit of the shareholder themselves, and for such conduct the company assets are insufficient to pay the debt of the creditor, shareholders are personally liable for the debt. Moreover, we should adopt the 19 category under Laya and Erin Home case in the U.S. legal system to be the standard of what situation that the corporate wealth should be pierced and hold shareholder personally liable. The benefit of revision this section is that the creditor will be able to receive the debt that the company cannot pay according to insufficient asset, because the creditor and third party can claim against the shareholder for the debt if the fact appear that shareholder used the company in bad faith. Secondly, The government should enact the ministerial regulation or special law to enforce and describe the duty and responsibility of shareholders of both private and public company in order to set the standard of the duty that shareholders should properly act when exercising the right to operate the company. So this could prevent the event that shareholder exercising the right in bad faith to operate the company. And this is come to final part of my video presentations. Thank you for your attention.